The creator economy has exploded, and so have its legal headaches. What was once a hobby is now a business bringing contracts, liability, and real legal exposure. Brands are showing up with legal teams, pushing creators they collaborate with to do the same. Add to that murky disclosure rules, sector specific regulations for health, food, and finance content, and consumer protection laws that hold influencers equally responsible as companies for their claims, and you know that legal counsel is a must have. Today, with Ishant Johri of Khaitan & Co., my colleague, ET's entertainment and film journalist Rajesh Naidu, and I unpack why creators are making a beeline for lawyers, who's responsible when campaigns and collabs go wrong, and what disclosure really means now. It's Friday, the 10th of July. I'm Anirban Chaudhary. This is the Morning Brief. Hi, Ishan. Very warm welcome to the Morning Brief.
Thanks, Anirban.
So, we are discussing this whole how the space of content creation or the creator economy is intersecting so much more with legal issues than it used to, right? So the first obvious question to you would be, are you seeing a measurable rise in creators or influencers approaching you or your firm in the last, say, 1 or 2 years?
So definitely, yes, Anirban, we have seen an uptick in clientele who specialize in content creation or influencers who work with brands. I think primarily the driver is that, content creation is a revenue generator for a lot of people now. It's not something that how they used to pick it up as a hobby earlier. And it comes with its own legal challenges, risks involved. And there's growing awareness. Even we see a lot of influencers on the opposite side who have proper legal representation. So, in that sense, we've seen that this space has become more organized, but there is a gap. And I think that gap is primarily with influencers who are still scaling up or who are engaging with brands which are still scaling up. There, I feel that legal awareness and legal representation is likely.
Now, if you look at the whole ecosystem, there are three entities, right? One is the creator, second is brands, and third is influential marketing companies. So, whenever there is any kind of breach, according to you, where does the whole system of onus lie?
So, under the legal framework, the brand and the influencer are the two parties in this ecosystem who are consumer facing, right? And they become primarily responsible for content that is created. Brands are supposed to create trust with consumers. They are responsible under the Consumer Protection Act, under the ASCII guidelines. So, the primary responsibility of any promotional content that is being created is that of the brand. The CPA and ASCII, they are required to do their own due diligence, again, to make sure that the statements that they are making are not misleading. They are saying only fair things. And therefore, the second level of responsibility equal to the brand is that of the influencer. The third entity that you refer to in this whole ecosystem is the influencer agency. Now, depending on what role they play in the transaction or in the dealing, is how their liability becomes clear. So if they're representing the brand in the sense that they're creating the script, etc., there'll be a contractual responsibility on them from the brand that they will make sure that they comply with brand related guidelines, that they're in compliance with legal frameworks, etc. Where they represent agencies, typically in a contract, a brand will expect them to be responsible for ensuring that the influencer is compliant with the contract and requirements of the law. So the agency is not directly responsible under the law, but their responsibility comes from the contract itself.
So, Ishan, tell me, from contracts to disclosures, what is the basic legal hygiene that you impart to them or start with? And what are the various aspects that you advise them on as they scale up?
Thing that they need to look at is the legal requirement when making any promotional content. One is, of course, your Consumer Protection Act, where you need to make sure that your content is honest, it's truthful, it is fair in competition. Then, depending on what product you're talking about or what sector it is intersecting with, there are a lot of sectoral requirements as well. So, for example, if you're talking about a medicine or a drug, so there's separate requirements for that. If it's investments, then SEBI comes into picture. So, those are those sectoral requirements that you need to be mindful of. The third thing is always making a disclosure that this is promotional content or advertising content, and that's where social media influencing differs from traditional ads, right? In traditional ads, it's advertising. While in social media marketing, it's always tried to be depicted as something that's organic in nature, which is not true. So these are the aspects that you need to look at. The next step is looking at your contract. What are you agreeing with each brand? And what are the terms and conditions of each platform where you're posting your content? There are plenty of resources available on the internet which are helpful for creators to understand what are the legal requirements. And if your contract or your requirements are more nuanced, then there's of course legal representation that you should.
So, Ishan, for example, how does an influencer deal with it if a brand sends them a free product with no cash involved? Do they still legally need to disclose it as an ad or a paid promotion?
This is something that happens fairly often. I spoke about material disclosure, that if you are creating something for a brand, then you need to disclose it. A lot of times the question comes that I'm not getting paid, but the brand sent me a freebie. That is also a material connection with a brand, and that also needs to be disclosed. Just because it's not a cash consideration doesn't mean that it is not promotional content for the brand. So you need to be really honest with your consumer that what you are creating is promoted
Got it.
content or whether it's just your organic review or feedback.
So this is a two-parter. One is among the various topics which are discussed on social media by these influencers, which topic, according to you, attract large number of legal cases? How does the law look at both influencers and consumers' point of view?
I think the maximum amount of legal issues that arise are in two primary sectors. One is personal care and beauty, and the other is in health and food and beverages, rather, right? And ASCI had come out with a report earlier this year on what kind of complaints they've seen, and they've also seen that these two sectors are the ones where there have been maximum complaints from consumers about either advertisements or influencer content. The reason this happens is because a lot of times this content either is not properly reviewed for what are the statements that are being made, or disclosures are not made. For example, an influencer will say that, oh, I use this XYZ product and my acne cleared in 7 days, right? All of these statements need to be backed by substantiation. So when it was a traditional ad, the brand team would look at the script, they would clear everything, but we can ensure that all claims are being substantiated. What happens in case of influencers is that sometimes that content review is not done, and therefore these claims arise. The other similar sector is again food and beverage. So much greenwashing that, oh, this only has herbal ingredients in it, or this is eco-friendly in a certain way. All of these claims need to be backed and need to be substantiated. Either the influencer must do their own due diligence, should have used the products to be able to make claims, or they should actually reach out to the brand and ask for information.
Many a time on a certain topic, let's say health tip, how does the law look at it when it comes to health and money related matters?
So recently, ASCI, together with the Ministry of Health, Ayush, came up with guidelines for influencers who are talking about health and nutrition. And there they've said that any influencer who's talking about this needs to disclose what are their credentials, and that disclaimer needs to run throughout the content. Now, this is important so that people know when somebody is giving you specific expert advice that they are in fact qualified to give that advice. Exactly for this reason, there's a lot of contradicting content floating around on the internet which could cause real harm. Similarly, SEBI takes a very strict view on influencers or people who are giving investment related advice without being qualified, and they've taken action against previously registered influencers who've been posting such content to make sure that they take it down, or in fact even to ban them. Now, what is allowed in this framework is to give generic advice talking about awareness of, say, investing. That is permissible. Similarly, broader advice that, say, hydration is good for you. That is permissible. But when you start getting into specifics and require qualifications, there are sectoral guidelines, and anybody who's getting into this should make themselves aware before creating or publishing such content.
Tell me, how aware our influencers about their rights when it comes to IP, and also how important is it for them. So for example, I was talking to a talent manager and he said that sometimes influencers take copying of their content as just another form of inorganic distribution and reach. If other influencers or others are copying them, it's just a form of, I mean, they just need to give a comment saying, boss, why don't you give me credit? And then it gets 2000 likes and people know that this has actually come from them. So they're not very hung up on IP. And this is irrespective of brands, their own content also. How do you see this?
So, Anirban, understandably so, because IP is a very nuanced thing, and how it translates into monetization or greater reach is a case by case scenario. Like, for example, if an influencer were to create an original song who somebody is copying, they might choose to let that be also because it's still a cover version and is promoting them, or they might choose to want to take it down, saying that no, I need attribution and I want my own song to become popular. So it's a question of where they are in stage of distribution, in their stage of popularity before they can take that call. But again, IP is very nuanced, and I wouldn't think that a lot of influencers are very, very aware of it because it's a very specific legal subject at the end of the day. It's not like consumer protection, which is simpler to understand. I think one very interesting thing that keeps coming up with influencer created content is when they start using third party work also, right? So, for example, some music is being used at the back of their video, whether they've taken proper licenses, whether that platform had an appropriate license, whether that license allowed them to use it with a certain brand or not. Those things are which are real gaps and risks for influencers. And that I think is something that they need to build more awareness on.
Tell me, what does a legal notice look like and where does it usually come from?
A legal notice could come from, say, the brand who has engaged you if you've not complied with your contractual terms. It could come from a third party IP owner, say a music label where you use music without taking appropriate permission. You could have been talking about another brand in a disparaging way, and in an untruthful way, it could come from them. So there are various risks, right? And a lot of times, depending on how far you are non compliant, the risk is also similar. So if say it's a use of a third party ID without permission, you could still get that license. But where you disparage the brand, you are looking at damages for disparagement, you're looking at potential takedown, there's reputational risk. So there's a lot that comes with a notice.
One last question from my side, Ishan. So I'm talking about independent influencers or content creators or comedians and their own properties, which is not backed by any brand. Is there a trend for them to get associated with a bigger name just so that they have access to a battery of lawyers? I mean, my specific example is Samay Raina and Latent. A lot of people say that he tied up with Netflix for, apart from the money, it's also the fact that he'll get a lot of legal backing that he did not get when it was an independent show. I'm, of course, veering away from brand endorsements and all that and asking you a very different question. But is that a trend as well? Or do you give that advice to content creators?
So, Anirban, I think we work with a lot of platforms, right? And platforms have larger liability. They're not like a social media platform, which can say that it's the user who's liable for their content, and therefore they have some sort of a safe harbor. But associating with a larger platform automatically ensures that content is reviewed in a certain way because that platform is looking at their larger reputation, their branding, their compliance framework, etc. So it works hand in hand, but I wouldn't say that content creators are necessarily associating with platforms for that.
So, from disclosure rules to due diligence, it's clear that the creator economy is growing up fast and the law is catching up with it. Whether you're a brand, an agency, or an influencer, the message is the same. Substantiate your claims, know your obligations, and when in doubt, call a lawyer. That's it for today. You were listening to this episode on The Morning Brief. It was produced by Vinay Joshi, sound designed by Amrit Reggie. Keep listening to our podcasts on your favorite listening platforms. Stay tuned.